Hi, everybody. Jack Roberts, Executive Editor with Heavy Duty Trucking here. The Supreme Court of the United States of America laid down a verdict on a case that has the North American trucking industry a little rattled. And we've invited Greg Feary, he's an attorney out of Indianapolis, to come on with us and talk us through this case. Good morning. Thank you for joining us. Tell everybody who you are and who you're with.
Thanks, Jack. I'm the president and managing partner of the Scopelitis, Garvin, Light, Hansen, and Feary. It's often just referred to as the Scopelitis law firm, and we are the largest transportation law firm in the United States.
Great. Thanks for joining us this morning. It's going to be really interested to get your perspective. So, taking a step back, what is the genesis of this case, and what were the justices being asked to decide in this verdict?
So this comes out of a highway accident where C.H. Robinson brokered freight to a motor carrier by the name of Carib Transport. And Carib Transport there was a highway accident, and Montgomery, I believe, may have lost his leg in that accident. So it's a highway accident underlying case, and the question became, could negligent hiring, which is a tort that most states have, it's a cause of action most states have, be preempted and not actually filed against and litigated against C.H. Robinson. And C.H. Robinson filed what is referred to as an FAAAA preemption. All the FAAAA just refers to the Federal Aviation Administration Authorization Act. And the preemption provision of that law says, in effect, this, that no state can enact a law with respect to rates, routes, and services, prices, routes, and services of brokers, freight forwarders, or motor carriers. There is a safety exception below that, which effectively is, except states can enact safety laws with respect to motor vehicles. That is not preempted. So the Supreme Court was asked to answer this question based on a split of circuits. There were the Ninth and Sixth Circuits were saying, no, this cause of action, this negligent hiring cause of action is not preempted. People can sue brokers for that. Seventh and 11th Circuit were saying, no, people can't sue brokers for that. That's preempted. The safety exception does not apply. That safety exception only applies to the operators of motor vehicles, to motor carriers. So the Supreme Court is really asked a pretty narrow question. Does that safety exception, which would, if applied, open up this cause of action to all brokers across America, does that safety exception apply to brokers? And their answer was yes, it does. It doesn't just apply to motor carriers operating motor vehicles. It also applies to freight forwarders and brokers, in this case, just brokers that select motor carriers. So what we have today is something that we've had as the law all the way up to 2023. It was only in 2023 that the 7th and the 11th Circuit said, no, you can't sue brokers for that. So for about 2.5 years now, only in the 7th and 11th Circuit, which is really only 6 states. The 11th Circuit is Alabama, Florida, and Georgia. The 7th Circuit is Indiana, Illinois, and Wisconsin. Only in those 6 states could you not sue a broker for negligent hiring. The rest of the country, and certainly in the 9th and 6th Circuit, you could. This decision now says you can sue a broker for that cause of action in all states. That effectively takes away that 7th and 11th Circuit preemption, just those decisions. So there's where we stand. It, in some ways, Jack, it just restores status quo to what the industry was facing back then. What I think is different now is it's so highly publicized that you're likely to see a larger volume of this type of allegation being filed with plaintiffs' attorneys.
Let me ask you this. Looking at the industry today, there's great concern over nuclear verdicts. Obviously, trucking fleets are seen as low-hanging fruit by a lot of plaintiffs' attorneys out there. And perhaps that is what some of the alarm that I'm seeing online is about. They're thinking that this, owner-operators, small carriers, fleets that are perhaps not as invested in advanced safety technology as some of the larger carriers are suddenly fearful that they're now a greater level of exposure for them. Am I wrong in looking at it through that lens?
No, I actually think that's a really good view of it. I think that's pretty accurate, Jack. The question, remember what this cause of action is that a broker had enough information to know or should have known that a particular carrier was not going to operate safely, right? It isn't that the broker picked a carrier that got in an accident. That's not what this is about. It's that the broker picked a carrier that was reasonably likely to get in an accident, or had the broker exercised reasonable care to look at how that carrier operates. Did they ignore that, or did they not check? So back to your point, and I think it's a really good one, Jack, is when you have a small carrier with virtually no safety information, or carriers that actually don't have great safety scores, whether that's ISS scores, some carriers have CSA basic scores or a safety fitness determination. Are those carriers in some jeopardy of not being selected by brokers, not being able to do business with brokers anymore, number one? And I think the second question, Jack, which is kind of some of the upheaval that's going on now, are small brokers gonna have a difficult time doing business with shippers who say, well, we're not sure what your carrier vetting process is, or do you have insurance for this type of risk?
How do you think this is going to play out in the coming weeks? Just general thoughts. What would you advise a small carrier or an owner operator right now?
I don't know that you're going to see an immediate light switch turn on and off on this one. In that regard, what probably you will see immediately is a number of litigations had been stayed pending the outcome of this decision. So any number of allegations against brokers for negligent hiring were just not going to be decided by lower courts because they knew that this decision was being considered by the Supreme Court, and they knew there was a decision coming down, so they stayed that. That stay will be lifted, and that now there will be a number of cases litigated on that subject. In addition, you'll likely see more allegations against brokers because plaintiffs' attorneys are now more aware that this is a cause of action. What does the small carrier or small broker do? Well, I think the small carrier is going to have to be even more vigilant about safety operations. What does that mean to a small carrier? It probably means at least being very careful about qualifying drivers, making sure that you have well-qualified drivers with a good safety background, number one. How about the small broker? Well, a lot of small brokers don't have vetting process. They don't have carrier selection protocol. They're going to have to start putting in place a carrier selection protocol that they importantly can demonstrate to insurance underwriters. We look at this. We pick carriers that are safe. What kind of information would be in such a carrier vetting protocol? Probably the ISS score, if nothing else. And now you probably know that is a score that state patrols look at. Carriers have an ISS score, and if it's above 75, they're required when they make a stop of a truck to do a safety inspection. If the score is between 50 and 74, it's optional that state patrolman do a safety inspection, and then anything under 50, they let them pass without a safety inspection. So it would be wise for brokers to take a look at that. And again, I've mentioned CSA basic scores. Ask for those. They're not publicly available, but brokers can ask carriers for those if the carriers have them. Most carriers don't have them. safety fitness determination, which is the satisfactory, conditional, or unsatisfactory. Again, most carriers don't have that, but the broker should be asking for it to at least determine if they do have it. So some basic things like that. Do they have the right insurance? Do they have the right authority?
Final question as we head out the door here, and this is a little more speculative, but if we're really being honest with ourselves, these have been the trend lines for some time. And it just seems to me that this ruling kind of reinforces what if you're a small carrier or an owner operator, you may not like it, but the longer you're not investing in safety equipment for your vehicle, your fleet, you're really you're playing against the house. And it's so just kind of, to me, what I think I see here is just a further reinforcement again, inside the context of nuclear verdicts and an aggressive plaintiff's attorney industry out there. Am I off the mark there?
I think you're spot on, actually. And I think I understand that there's economics for these small brokers and small carriers, right? How much can they invest? How much profit margin do they actually have? But I think the new reality will be that shippers are going to have to pay more, probably willing to pay more. Brokers should be able to turn that into a greater profit margin, be willing to pay smaller carriers a greater profit margin. And those smaller carriers hopefully shall allocate some of that profit margin into, as you said, safety equipment, safety training, carrier selection protocol, driver selection protocol, all of that. So I think you're spot on, Jack.
Thank you so much for your time and your thoughts today.
Thanks, Jack. Appreciate it.
Greg, good morning.